Good morning, everyone. Today, we begin with one of the most foundational inquiries in legal theory: what is law and where does it come from? Understanding sources of law is not merely academic, it shapes how we interpret statutes, argue cases, and even critique the legal system. By the end of this lecture, you should be able to situate Indian law within broader jurisprudential traditions. Meaning of law. When we speak of law, we are not referring to a mere set of rules. Law is a structured system of norms recognized and enforced by the state. It is both descriptive, reflecting society, and prescriptive, guiding behavior. Notice that law carries legitimacy not just because it exists, but because it is accepted as binding. This acceptance distinguishes law from mere power. Significance of law. Law performs multiple critical functions. It maintains order, but more importantly, it balances competing interests. Think about it. Without law, rights would be abstract ideals. Law converts them into enforceable claims. It also acts as a dispute resolution mechanism, replacing chaos with institutional processes. In modern democracies, law is the backbone of governance. Schools of law overview. To truly understand law, we must examine how thinkers across history have conceptualized it. Each school of law represents a different answer to the question: what is the true source of law? These are not mutually exclusive, they often overlap, but each offers a distinct lens through which legal systems can be analyzed. The natural law school argues that law is derived from moral principles inherent in human nature. According to this view, an unjust law is not truly law. This raises an important question for you: should legality depend on morality? This debate becomes especially relevant in constitutional law and human rights jurisprudence. In contrast, the positivist school separates law from morality. Law, according to this view, is valid simply because it is enacted by a recognized authority. This is particularly useful in understanding modern legal systems where certainty and clarity are essential. However, it also invites criticism. What happens when the law itself is unjust? The historical school emphasizes that law is not created overnight, it evolves. It reflects the customs, traditions, and collective consciousness of society. This perspective is especially relevant in India, where many legal principles have roots in long standing customs. The sociological school shifts the focus from abstract theory to social reality. Law is seen as a tool for social engineering. It must adapt to societal needs and promote welfare. This is the philosophy behind many welfare legislations and public interest litigations in India. The realist school takes a very practical approach. It argues that law is what judges actually do. In other words, law is not found in books alone, but in courtrooms. This perspective reminds us that judicial interpretation plays a critical role in shaping legal outcomes. Sources of Indian law. Now, let us narrow our focus to India. Indian law derives primarily from three sources: customs, judicial precedents, and statutes. These sources interact dynamically, often complementing and sometimes conflicting with each other. Customs are source of law. Custom is the oldest source of law. However, not every practice qualifies as a legal custom. It must be certain, reasonable, and continuously observed. Many aspects of personal law in India still draw heavily from customs. Judicial precedence is a cornerstone of common law systems like India. The doctrine of stare decisis ensures consistency and predictability. But remember, precedents are not static. Higher courts have overruled them, allowing the law to evolve. Statutes represent the most authoritative source of law today. They are enacted by the legislature and reflect the will of the people, at least in theory. However, statutes often require judicial interpretation, which brings us back to the importance of courts. To conclude, law is not a single static entity, it is a dynamic interplay of ideas, institutions, and social realities. Understanding its sources enable us not only to interpret the law but to question and improve it. As future legal professionals, your role is not just to apply the law but to engage with its deeper foundations. Thank you.